Morning, Judge. Nice to see you.
See you again, too.
We know each other. I'm still Mike Sasso. The protocol is going to be each of the commissioners will introduce themselves. We have one commissioner who's appearing by speakerphone. And after that, we'll give you 2, 3, 4 minutes, whatever you think you need to make a little opening comments, opening statement about yourself. We'll then have a Q&A period of about 20 minutes. And I have the unpleasant task of being the gatekeeper, so I'll jump in at some point in time. And then you'll have 2 or 3 minutes to make some closing remarks.
Thank you.
Good morning, Your Honor. Vincent Citro, the law offices of Horowitz and Citro.
Good morning, Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bardos of Gray Robinson.
Mike Sasso of Sasso and Sasso. I have Commissioner Amanda Perry Carl on mute on the squawk box.
Brett Renton, Schutz and Bowen, Orlando.
Nice to see you, Your Honor. Pedro Brownlee, the Brownlee Law Firm.
David DeArmas, Kramer Price and DeArmas.
Morning, Your Honor. Scott Thomas with Burr and Foreman.
Well, thank you for having me again. So it seems like it's just a few months since I was here. So when I was in undergrad at Michigan State, I had a triple major in history, philosophy, and political science. Eventually, they called that pre-law humanities, but I didn't want to be a politician, but what I was interested in was the formation and deformation of governments and the way it interacts with the rights of the governed. Eventually, it became clear to me that law school was probably the best option. Now, that was a big deal in my family because on my mom's side of the family, nobody had ever attended college, let alone been accepted to postgraduate education. On my dad's side, there was one person with a college degree. It was my dad. He was awarded a 4-year degree from General Motors Institute as part of his corporate training. So there was a lot on me going to law school. But I went on to attend law school at Washington, D.C., and the education inside the classroom was nothing compared to the education outside the classroom. I literally was within walking distance of the heads of all 3 branches of our government. So it was 3 years of a lot of growth and deep thinking. But I graduated and I moved to Orlando, and philosophical thinking gave way to strategic thinking and running a law practice and representing my clients and seeking their interests. But things came full circle in 2002 when I was elected president of the Florida Adoption Council, which was our statewide professional organization. The first task that I had was to totally rewrite Chapter 63 of the Florida statutes. That took me to Tallahassee many times, met with lobbyists, met with bill sponsors. I served as a topical expert for committee meetings, and essentially had a front row seat to how laws are made in Florida. That, in turn, led to my ability to teach law school at Barry Law School. I taught adoption law for 12 years. And as part of that, I was teaching students about the interplay between the statute and the court's interpretation of it. And I tell you all of that because that's what I brought to the court in 2015. So I came in with an understanding of what legislative intent means and doesn't mean, what separation of powers is and why it's important, and why the structure of our government needs to be maintained. So I brought all of that to the bench. I currently serve in the General Civil and Complex Business Litigation Division over in Orange County, where I'm handling cases in many different areas of law. And pretty much every day, I'm bringing that to my cases and that understanding. So I've been sitting here watching the changes in our court system, rather dynamic changes from the Supreme Court and through the appellate courts. I have wanted to be an appellate judge for a long time, and now I sort of feel like I'm sitting here saying, Coach, put me in the game, because there's a lot going on the field right now, and so that's why I'm here. And I know you all have my application, and happy to answer any questions you have about it.
Thank you very much, Your Honor. I had the pleasure of specifically vetting you, calling all your references, talking to other individuals, and they had fantastic stories about helping children, your time rewriting that statute, working with you on the legislative side, stories of efforts behind the scenes where really you could have jumped into a spotlight position that may have helped you with campaigns or may have been for other causes, and you put that aside and really made it about the kids. And so I want to say thank you for the things that you have done in the past and continue to do. One of the things I thought interesting was a program with the Rotary Club that I understand you wrote actually some policies and procedures and served in a role over there dealing with kids coming in and safety coordination. Can you tell us a little bit about that program and your role with that charity?
Sure. Wrote the protocols would be kind of a stretch. They asked me to find some protocols, and so I found some protocols for Rotary Youth Exchange that were being used in the Boys and Girls Clubs and YMCA because they didn't have any. And so I delivered those to the chairman, and they basically changed a lot of the Boys and Girls Clubs to Rotary Youth Exchange, and eventually adopted those protocols that they really needed to make sure that a program that's dealing with teenage kids is actually working to have appropriate safety parameters in place so those kids are safe. So it's a role that I have to be pretty careful about because I can't allow myself to drift into giving them any kind of legal advice. I have to stay in that role of just being one of their directors, and I've told them many times I can give you kind of social science advice. I can't really tell you anything legal, so we do have a lawyer who provides that advice for them. But,
they made that abundantly clear in the phone calls.
I have made that abundantly clear to them. So it's a great role, and I work with kids who are inbound and outbound. We currently have 22 kids in from many different countries, and we have 21 kids out. So.
And you know, you have applied a number of times to our organization, so we're not unfamiliar. One of the things that this body had kind of requested in the past in looking at is that you had a deep level of knowledge as to family law, but maybe other areas of the law, civil, criminal, really hadn't gone into. And this year you transferred over to civil. One of the things a lot of your references talked about is that you didn't just go into civil and say, okay, I'm going to do it just like everybody else. You looked at the system and said, is there a different way that we could do things? And you've implemented a jury selection procedure. Can you explain that a little bit and why you took it upon yourself to say, hey, you know what, let's do it differently?
Took it upon myself to start the dust storm. So almost immediately when I arrived in civil, I was handling jury trials, and the civil division has some genuinely excellent attorneys that are appearing in front of that court, but they can blow through jurors. And we were in a circumstance where it was happening that the panels were blowing and the jury room couldn't provide any additional jurors. There just weren't enough. So I attended a seminar, actually, that was being put on by Judge Riepel from down in Miami and Judge Griffiths, and they were talking about how they do jury selection in Miami. And down there, when they pull the panel in, it's a little bit different from what we do here in Orange County, they seat the jurors, let's say 1 through 30, in seats 1 through 30. They allow a voir dire to continue with regard to those 30 jurors, and then at the conclusion, they randomly select jurors from the 30 to bring into the box. So they don't do 1, then 2, then 3. They might pull 12, and then 7, and then 18. And what it was doing was helping the lawyers to focus on whether or not these jurors were inappropriate for the panel, as opposed to the juror in seat 17 is the best juror for this particular type of case. You need to blow up the first 12 in order to get to 17. And so what prompted that was I had a slip and fall case that went through 102 jurors. And got a call from the jury room saying, basically, are you kidding? Since I've implemented it, every single trial, the lawyers have left preemptories on the table. They haven't used them. And the jury, they're good juries. They're coming back with good good decision-making, so I don't see any problems with it, and we are definitely using less juries. We've had some discussions with some of the lawyers in town. It's a little uncomfortable for them, but they're adjusting and they're liking it. So I think there's other judges now that are using it, so Judge Roach had asked me if I would be the guinea pig for it. I agreed to do that, and now I think Judge Roach, Judge Schreiber, and a couple of others are using it, the same system.
And so just kind of swapping gears off of that, and then I'll open it up to the rest of the panel, because I know they'll have a number of questions. If you had to compare yourself to members of the Florida Supreme Court or members of the 5th District Court of Appeal, which one of those sitting judges or justices do you think most reflects similarities to you in your judicial process, your philosophy, or just who you are? Who do you think is most like you? Not who you would like to emulate, the other way around.
And in terms of, so I don't know them personally, a lot of them, but just from reading their opinions, I think that I connect a lot with the writing style of Barbara Legault. I've read a few of her opinions, and she has a sort of 1, 2, 3 decision kind of approach, and I even lay out my orders with facts, law, conclusion. I try to be as direct as I can and as closely tied to the statute or the case law so that it flows really well. So I would think that I must have a similar personality to her.
Thank you.
Are there any, can you think of any decisions in particular that she authored that are standing out in your mind?
I loved her decision in Israel versus Governor DeSantis. I think she just cut right to the chase and handled it very closely tied to what the Constitution requires, and dispensed with it very clearly. There was no muddling around or dicta. It just went straight to the point.
Your Honor, I think we've touched on this maybe before. You certainly in your private practice, and really some of the bench, although you have a civil assignment, have been admirably engaged in the front lines in some very sensitive areas, important areas of the law. What is it that drives your interest in, you're not still part of that, but they're somewhat removed from the front lines, coming to an appellate bench? But what's your interest in that?
So I love what I do, and I'm loving being in civil, but at the core, I'm still an introvert, and I like to kind of sit there and research the law and get the right answers. There's a dynamic quality to the trial court that some people thrive on, and some people just, it takes a lot of stamina out of introverted people. So I'm basically introverted, and I love the legal side of it, but I would love the opportunity to be able to sit there and do legal interpretation, and I really am kind of driven to have the right answer. I typically find that when I don't leave the courthouse till very late every night. It's me and Keith White, two of us leaving at 8:30 every night, because I want to make sure I have the right answer for the next day. So that's essentially what I'm doing, is what appellate judges do. They look at the cases, they look at the statute, and they're trying to make sure the decision was right. I'm trying to make sure the decision's right before I render it. But so I think that's what draws me to the appellate court.
Certainly on the trial bench, everybody want the right answer, but we'd like it right this second, if you don't mind.
Exactly. And the good news about civil is that they are very good about giving you memoranda and cases and stuff ahead of the hearing, so that you can't stay up until midnight reading that stuff.
They still want, we still would like a ruling when we walk out of the courtroom. Right.
We'll also take fees and costs if you
If you spend the entire evening before doing that, then they often get that
Yeah.
ruling before they leave.
Thank you.
Just out of curiosity, has the the jury selection system been tested? Has it gone up on appeal, or are there appellate issues that might arise that you're aware of?
It went from Miami, and Judge De La O was the judge down there that handled the opinion down there, and there's nothing wrong with random
I
selection.
don't think there's anything wrong with it either, but I'm just curious if
Yeah.
I think some folks at M&M would have a hard time with it, that's why I'm curious.
They do.
Okay.
But, we've had a little compromising about agreed upon cause challenges. So initially, Judge De La O said, you don't handle any challenges until you start randomly selecting jurors. And so I did that on the first couple of trials, but that's really hard on people who have language challenges or have genuine hardships to make them stay there all the way through that process. So I have modified that, and we do agreed upon cause challenges and language and hardship and those things.
So since taking your new assignment, what would you say was the most challenging legal issue, taking the jury selection process out of it, that you've confronted? And what about that was challenging to you?
So everything was challenging to me.
I get that.
My description of my first month in civil was like drinking from a fire hydrant. In terms of issues to deal with, I think from legal issues perspective, getting a handle on things like collateral source, boarding of medical expenses, stuff like that, where the case doesn't be all over the map, and we're trying to bring it back to a place where there's some clarity on it. I certainly have spent a lot of time perusing the York case and trying to figure out exactly what gets boarded and what doesn't get boarded. And some of those cases have some complex issues with collateral sources. So a lot of just trying to think it through and figure out the reasoning of the courts on stuff like that. That one's been particularly challenging. But it's all challenging. Everything is learning in civil, because probably the hardest thing for me to do, shifting from dependency, where in any given hearing I knew more than everybody in the room about dependency, to civil, where I knew less than everybody in the room about that particular area of law. So it was a lot of work to always be prepared and understand the legal issues, and really just without that knowledge base of that particular area of law, whether it was personal injury or medical malpractice, whatever it might have been, I was coming into it with a tremendous learning curve on that area of law. So I was constantly spending 12, 15-hour days for quite a long time. I got down to about 10 or 12 hours a day to be prepared for stuff. I didn't even know that you needed to cancel a note on a foreclosure when I first got there. But I worked very, very hard in the last 9 months to learn all of these different areas of law that civil deals with, and it's been an incredible experience, quite a ride. So that was an adjustment.
Could you talk a little bit about your work in the legislative arena, working on drafting Chapter 63 and getting it passed through the legislature, and how your experience with that might have influenced your philosophy of the law or the judicial branch and its role?
So there's a little bit of history behind how I came to be involved in Chapter 63. And the history behind it was that there was a prior statute passed in 2001. So the statute I worked on is from 2003. In 2001, Senator Skip Campbell was working on a bill to make some changes to Chapter 63. And I'm not certain who was advising him on the bill, but it wasn't the Florida Adoption Council. It was coming from other arenas. And one of the things that they decided was that they needed to improve the ability of birth fathers to be notified about potential adoption plans. Their solution to that was to require birth mothers to publish in newspapers of general circulation in every jurisdiction through which they had lived or traveled in the 12 months before the birth of the baby, their name, address, height, weight, hair color, eye color, and dates and places on which they believed conception might have occurred. You can imagine how the adoption community responded to that. And so it became known as the Scarlet Letter Law, and that publication requirement was an obligation regardless of the status of the birth mother. It could be an incest victim, a rape victim, it didn't matter. She had to publish all that information if she wanted to place a child for adoption. The Florida Adoption Council tried very hard to stop that bill from becoming law. They tried to talk to then Governor Bush about not signing the law. It didn't work, but the law went into effect in October of 2001. The first 6-month reporting period for the Department of Health that where you would see actual statistics was from January to June of 2002 after that law went into effect. And of course, adoptions plummeted because birth mothers were not willing to do that, but abortion increased by 17% during that time period, the largest increase in the abortion rate in the state of Florida in the history of records. And so it literally shifted women from adoption decisions to abortion decisions in order to avoid the publication of their information. That prompted very quick action from Governor Bush. I was elected president of the Florida Adoption Council on July 1st. On July 7th, I got a call from Skip Campbell saying, we need to rewrite this and we need to do it quickly and I need you to handle it. So that's how I got involved in it. So it was taking it back down to its foundation and rebuilding it in a way that properly balanced the interest of all those parties, the birth mother, the birth father, the child, and the adopted parents. So it's a complicated transaction involving a lot of constitutional rights, privacy rights, a lot of those issues that are involved in it. So I pulled together the folks at some of the most experienced brain trust we had in our legal community that handled these types of cases. And we typed the strike through and underline in my office and then delivered it over to Skip Campbell's office. They were going to be the bill sponsor, which was sort of an odd pairing, but they were going to marshal it through. And so I wound up meeting with our lobbyist quite a bit, and I was taken around through the Capitol building to meet with other potential bill sponsors very quickly. Other bill sponsors jumped onto the bill, and they asked me to attend many committee meetings to talk about the bill. Didn't have a lot of need to talk about it. It seemed like there was a lot of support behind it that was coming from behind the scenes for the bill. But the most important takeaway for me was that I drafted the bill with the understanding of what the intent was behind everything in that bill. It was 4 years later that I found myself briefing in the Florida Supreme Court defending that statute, only to have Justice Periente tell me what the legislative intent was for that bill. It was a little eye-opening. It was not what I thought I was thinking. It certainly wasn't what we said in the statute. She had no problem with changing the word may to shall, and basically unsettling a statute that was very clear. And so that in turn caused us to have to go back to the legislature and amend the statute because we had a disconnect between the Florida Supreme Court and the statute. So we then had to go back to the legislature and change the word may to shall in the statute. So it's now shall in the statute. It was the Supreme Court we had to deal with. So those experiences were formative. And I definitely bristle when I see courts talking about legislative intent as a justification for changing something that the statute says.
Having had that experience, if you were on the appellate court and if you were asked to interpret a statute, and the statute, let's say it's a statute that's not particularly clear, or maybe there's an ambiguity in the statute, where would you look to determine what the proper interpretation of that statute is?
To begin with, I don't think there are very many statutes that aren't clear. I think sometimes statutes are clear and fact patterns are difficult to apply that statute to. I don't often find statutes that are just genuinely ambiguous. But if I did, the first place to look would be to other courts' analysis of that. And so there's, and that is typically what I do. I will, whether it's ambiguous or not, I typically will pull other cases to see how that statute has been interpreted. Smart people who have looked at it before may have insights that are helpful to me in defining it. So I'm certainly not gonna disregard that. I would bring that to the table to begin with. But then ultimately, I think you have to, when you don't have something directly on point, I think you have to read the cases, read the statute, and get a sense of the most appropriate application of that statute to the facts that you have. And I think I just had that. I'm going back this afternoon to take a verdict, but in my directed verdict motion, I had a situation like that. We have a statute that talks about the contributions of joint tortfeasors to when you have more than one tortfeasor that's involved. We have a lot of case law that talks about the subsequent accident situation. So you've got accident 1 and accident 2, and they happen a month or two apart, and how you address that. In my particular case I'm dealing with right now, we have a plaintiff who stepped on a broken sidewalk and fractured her ankle when it rolled. As a result of that, she then stepped forward and tripped over a curb. The sidewalk belongs to the county, the curb belongs to the hotel. And so we have two different defendants in the case, and the argument from the hotel is, well, it's all part of the fact that she stepped on the broken sidewalk. Of course, the county is saying, no, it's two different accidents. And so, two different injuries. One is to an ankle, and then she injured her knees on the fall over the curb. So that is a classic example. And so I certainly read the cases that were provided by the lawyers, but then I also found some other cases that talked about when it is a natural progression. So that makes it one incident. So they are joint tortfeasors. It's not two separate tortfeasors.
Interesting.
But that wasn't clear in the statute.
No, because the statute simply talks about when two different tortfeasors contribute to a single injury. So they were making the argument, she injured her ankle on the sidewalk, she injured her knees when she tripped over the curb. But if you read the case law, and we don't have that fact pattern,
Right.
but when you read the case law and they're talking about accidents that happen months apart,
Yeah.
it's different from where there's a sequence. And I actually found a case where a teenager had dove into a pool, removed a grate at the bottom of the pool, and got his arm stuck in the grate, and then subsequently drowned because they couldn't get the off switch for the suction. And so the argument was that it was two different injuries that he had, there's first the injury in the grate, and then there is second, the fact that somebody had put a lock on the door where the off switch was, and they couldn't get to it in time to save him. And in that case, they found it was a natural and continuous sequence. So that's exactly what I was talking about. That fact pattern, although very different, has a lot of elements that are similar, and it makes a lot of sense.
It happens with auto accidents a lot, too. There's a number of
Sure.
auto
Yeah.
accident situations.
Judge, I have the unhappy task of being the timekeeper.
We can talk about this all day, Judge.
This is good stuff.
Nobody else wanted to do it.
All right.
Thank you so much, and I thought I should apologize for interrupting this wonderful discussion, but this is your opportunity to make any closing remarks.
Well, all I would like to say is that I'm aware of the fact that I have been here before, and there's been a lot of focus on the fact that I had such a deep background in family and juvenile law, and I really had not branched out into jury trial areas and civil areas. And I am there now, and I am handling general civil and complex business litigation right now. It's complex business litigation for another few months until we send that to Judge Traver in October. And I have definitely grown as a judge in that process. I am handling different types of cases and different issues. And I think that it's made me a better judge, and I think it makes me better prepared for a position on the 5th District. So I appreciate the time that you spent with me today.
Thank you.
Thank you for coming.
Thank you for your service, Judge.